Thanks, everyone. Welcome to the second panel session. My name's John Baines. I am let me get this right, Senior Data Protection Specialist at the law firm Mishcon, non-qualified, but I advise on all areas of data protection, freedom of information law. I'm also just a bit of a pain in the neck in general on the topic. I try my best, Pat. I'm very interested in the area of enforcement in particular. As you'll have seen, I do potentially have a loud voice when people are talking very loudly. I am also, in my sort of spare time, chair of the National Association of Data Protection and Freedom of Information Officers. And it was once said I ran it like a benign dictatorship, which I thought was very rude, but yeah, less of the benign. Yeah. Anyway, you're not here to hear me today. You're here to hear about a fantastic panel talking about the changing enforcement in the UK around data protection. Up shortly, we've got David, who I'm sure you all know as convener of the conference. We then have Claudia Berg, who is General Counsel at the Information Commissioner's Office, and then Jim Killock, who's Executive Director of Open Rights Group. Just before I hand over to David, someone, we believe, left a USB stick in one of the computers here. Does anyone?
Your computer to find out who, John.
I've tried. It's not working anymore, Michael. I don't know why.
What's on this? Yeah, look.
No one.
No, I admit.
I'll just think.
Okay. Well, it is here if anyone didn't want to own up. But no, without further ado, I'll pass over to David. You all know him, but he is your Director of CIPIL, Professor of Law and Open Society.
That'll do.
And we all know him. Thanks, Dave.
Okay, well, thank you so much. It's really great, and thank you, John, for that very, very kind introduction. So, my talk to kick off this panel is going to itself be quite introductory. What I want to do is to provide an overview of where regulatory enforcement sits in the UK in two ways. One, an overview of the formal framework, and then an overview of the Information Commissioner's track record during the GDPR era. And not just the track record of the Information Commissioner, but also of those scrutiny bodies, the Tribunal, which we've already heard mention of today, and also of Parliament itself. I'll then move forward and look at the Data Protection and Digital Information Bill, DPIP. I found out a new acronym today. This is great. DPIP and what it is proposing, and suggests that it's not probably going to help matters much. Indeed, it might hinder things. And so I'll chart at the end some possible ways forward, which I think would tackle some of our enforcement issues and problems. Just a really quick timeline. I'm going to do this quite quickly because you are an expert audience, and most of this I'm sure you know, although some people from the EU maybe don't follow what happens on the Brexit aisle in quite the detail that we do. The common date for all of us, though, is obviously GDPR coming into force in almost 6 years ago now, in 2018. Important to note that the privacy and electronic e-privacy rules remained unchanged. And in this jurisdiction, the supervision of those rules in and of themselves also remained unchanged. The next key date is already over 3 years ago, the end of the Brexit implementation period, or the transition period is sometimes called. That's when, the one-stop shop fell away in the UK and the Information Commissioner became solely responsible for all data protection enforcement within this jurisdiction. And it's been over 2 years, so that's the third date since the digital DPIP has essentially been on the table of Parliament. So that's a third date to bear in mind. Again, really basic stuff, but we maybe want to make a distinction when we look at enforcement between GDPR and PECA. I'm sure you all know that distinction. Obviously, PECA is additional to GDPR with specific rules on electronic direct marketing and probably more importantly, or I'd say definitely more importantly, the confidentiality of electronic communications, which have huge implications for the way in which digital services operate, particularly you think of cookies and the storing and retrieval of information on end devices. So why that matters in an enforcement context is, yes, there are some key commonalities. Anyone can request ICO action. The ICO have fining powers. They also have enforcement notice, injunctive powers, and they have information investigation powers. But the GDPR is massively beefed up. Requests aren't just requests, they are formal complaints, which I would argue prompt formal legal duties. The ICO's investigatory powers are much more far-reaching, including the potential for assessment notices. That's actually literally going into premises, going onto systems, looking through things. I would argue that enforcement is obligatory under GDPR. It's not clearly obligatory under PECA. The fines are obviously significant. The fines in PECA are currently limited to £500,000, which is not really going to cut the mustard in most circumstances. There are also some criminal offences, which I won't actually talk about. Okay, and you know all this. The fines are potentially huge. So all of the substance of data protection attract fines of up to 4% of annual global turnover, which we know runs into the many hundreds of millions of pounds, possibly billion, actually, you know, in large organisations, and even in other contexts can be up to £17.5 million. And the integrity or discipline duties attract still significant potential fines, 8.5 million or 2% of annual global turnover at a maximum. The key thing I want to add and want to emphasize here, though, is that under Article 83, the ICO has an obligation to fine. It has an obligation to fine in a way that is effective, i.e. actually ensures a good level of compliance, and dissuasive in the sense that it provides incentives in the system to ensure that poor compliance doesn't happen in the future. Of course, all of that needs to be proportionate, but that is subject to the other two, it can't be interpreted in a way that makes it not effective or not dissuasive. Now, Recital 148 provides a gloss on that, but it's a gloss which also emphasizes the stringency of the formal regime. It says that penalties, including administrative fines, so other forms of penalties could be an issue. I talked about the criminal provisions we have, including administrative fines, should be imposed for any infringement of this regulation. So an obligation to fine, in addition to or instead of appropriate measures being the sort of injunctive and other forms of action which are listed also in the powers of data protection authorities. And then that you get the gloss in the case of a minor infringement or in the quasi-household purposes type area, disproportionate burden to a natural person, but that isn't really very relevant for organisations. Only in the case of a minor infringement may a reprimand be issued instead of a fine. In other words, this recital seems to be saying if it's not minor and it's an organisation at issue, you have to fine. You're expected to fine. We also have a gloss on the enforcement duties. Of course, enforcement is the first duty of data protection authorities. It's listed first in the law. And we have a judgment, a Grand Chamber judgment in Schrems 2, which is before the end of the implementation period, which makes it crystal clear that the supervisory authority, their primary responsibility is to monitor the law and to ensure its enforcement. All the other things are important. They're there, guidance and so on and so forth, but that is not the primary function. It's maybe things which academics or civil society do. Lots of people do that, but your key task is the task to ensure enforcement. And also, obviously, Schrems 2 dealt with complaints, saying that there was an obligation to handle complaints with all due diligence. There was an obligation of investigation. There was also an obligation to take appropriate action to remedy any findings of inadequacy. And that's quite an important gloss, because we have in recital 148 appropriate measures. What does appropriate mean? Well, the Court of Justice tells of that. It must be measures which remedy the problem, which ensure that any non-minor infringement is no longer there. It is an elimination of that infringement. That is what is appropriate in GDPR terms. Now, this may all seem too stringent, and it is stringent, to be fair. The GDPR was designed to be stringent. The track record in the UK has been rather different, to be fair. I think if I'm going to be as charitable as possible, I think one would have to say it's been rather different. There has been an increase in income and resources, so it's not clear that that is the restraint. Indeed, the ICO has roughly 1,000 people working on data protection. It's one of the best resourced regulators in Europe. But the number of fines is absolute single digits. We're looking at, I mean, the last annual report, to be honest, seemed to me to be inconsistent information. It actually said that there were 2 fines at 7.6 million, but when I counted them, I got 3 fines at 13.4 million. but nevertheless, these numbers are so small, alongside, tens of thousands of complaints coming in from data subjects, as to be almost certain to a controller that they're not going to be fined. That they're whatever, it cannot be that there are no minor infringements in these systems, and the ICO never come across anything except in, the 2 or 3 instances they take action a year. The number of fines actually has dramatically decreased since GDPR in the UK. The 18 or 19 period, I started this from when the GDPR started, but they were using the old system because the processing, it takes time to investigate, it takes time. We were having about 20 fines a year, 22 fines a year. That's dropped by an order of magnitude down to around about 2 or 3. The figures in some years have dropped as well. I mean, in the last but one reported period, you were looking at less than £200,000 for the entire fining of the entire ecosystem. I mean, that is almost nothing, to be fair. I think it's fair to say that is almost nothing. Injunctive notices, which are often talked about as another possibility, have always been almost absent from our system. You can see in several years that they have been literally 0 injunctions to bring infringements to an end. And yet we're told in Court of Justice case law that must be the action. To take appropriate action is an obligation to bring infringements to an end. But there are no injunctions issued in several years. And last year, in the last reported period, there was just 1 injunction. PECA might look better, but PECA, mainly it's fines. But here we're really talking about spam texts, spam emails, these sorts of things. They're not the significant issues of the way in which data is being used and misused in the system. They are a niche area which really doesn't touch the data ecosystem. And in any case, I mean, the numbers are not that significant to change things in a broader sense, I would say. Now, COVID may well be mentioned, and I do get that COVID was a challenge, But it's important to recognise that the approach of the regulator was locked in well before COVID. The 2019 to 2020 report, which was essentially about the pre-COVID situation, was very proud to state that 75% of the budget was being spent on proactive engagement, leaving at the very most only 1/4 of the budget, or I suppose roughly the equivalent of 250 people or whatever compared to 1,000. I mean, it was less then actually, as the resources were less, but only 25% for investigation and enforcement. And yet, how does that relate to what the Court of Justice Grand Chamber has told us are the primary functions? Yes, there's good guidance, but nevertheless, that is not the prime function of a regulator. And the soft approach, you know, we're told achieves great results, but the proof is really in delivery. And many people we might hear later have very serious concerns about very serious illegality, which has not actually been gone away. Okay, so let's turn to where has been the tribunal and where has Parliament been during this 6-year period? Well, a lot of us had very high hopes that the Section 166 procedure, the order to progress complaints and the order for the ICO to take appropriate action in response to a complaint, would be interpreted in a substantive way, particularly when we saw the word appropriate. We thought, great, you know, this actually marries up with some of what the GDPR is talking about. Unfortunately, the tribunal has interpreted the order to progress complaints as purely procedural. They will not get into the merits. If the ICO, and this is actually from the Killock and Veal, they're both here today, case, if the ICO close a case, and they close a case with no action, actually not even potentially a full investigation, particularly after DELO in the Court of Appeal, that is fine. The Commissioner is judged to be the expert regulator who is in the best position to judge on the merits, and the tribunal has said that it is not there to look at the appropriateness or otherwise of what the regulator is doing at a substantive level. So where on earth does that leave the data subject? Well, we might think, well, the data subject can go on a kind of group basis to Parliament and say, you know, the ICO is overseen by the Digital Culture, Media and Sport Committee. It was for 5 years. Now it's the DCIT committee because it's moved into science and technology. Surely they are going to scrutinise the ICO according to this case law, according to these obligations. Well, unfortunately not. During the 5.5 years, they've never held a single inquiry looking into the work of the ICO. And they did actually launch an inquiry. I have to correct myself. It held one hearing and it never produced a single report. But what they've really done is chased after headlines. You know, certain big hot button issues come up, they look into it, they may get the Information Commissioner in to comment on it, and they produce a splash and then they move on. There is no holistic scrutiny going on, which is not to say that they aren't very good people and working on very good issues in Parliament, in the regulator and in the tribunal perhaps, but it's not providing that holistic protection that data subjects need. Okay, I realise that time is short. The DPIP bill, you would think, would start to address some of these issues, but actually it seems to grant even more discretion to the Information Commissioner. I do appreciate that complaints can be very niche or even misjudged, but nevertheless, the fact that the focus is that there's no need to act when it's vexatious and that the controller must be given its responsibility to act is not really helping matters. Certainly, it's not addressing any need for public interest cases to be more firmly acted upon by the regulator. It may not hinder it. I accept that. The objectives of needing a strong focus on data protection, which is Court of Justice case law, are being lost by the new priorities on public trust, innovation, competition, crime, national security, and so on and so forth. Nothing, again, which is directly wrong about that, but it's not addressing the sort of harms that I'm talking about. Neither is the Secretary of State's power to set out strategic priorities which the ICO must have regard for. There's a danger that that will result in the pick and mix approach, the selective approach, which is precisely the problem, the sort of 2 or 3 actions a year as a final result, rather than the many hundreds that, frankly, the GDPR seems to promise. PECA powers will be brought into line with that of the GDPR, and the GDPR, then the ICO will become a board. Nothing, again, wrong directly with those changes, but the powers of the GDPR, including the lawfulness of processing, which would capture a lot of PECA issues anyway, are not being exercised at scale at all. So it doesn't really matter whether the powers are there if they're not being exercised. Okay, so where do we go from here? Well, I think that there are 2 things which really could improve matters. One is focused on improving individual scrutiny of individual issues, of which there are many. And that, I think, returns us down back to the tribunal. The tribunal should be overseeing the appropriateness of the ICO's substantive response. That was the promise of the order to progress complaints mechanism, but it has been interpreted otherwise. We need a new wording which captures, at least as regards public interest cases, because I do appreciate that, every individual case is an overwhelming burden for the regulator, but public interest cases where there is a clear concern should be subject to tribunal oversight, and civil society groups should be given the ability to bring those complaints without having to get specific mandates from specific data subjects. Preferably, they should also be given some funding to be able to bring well-argued cases. The other aspect is holistic scrutiny. So that should be being done by Parliament, but clearly is not being done by Parliament. And I think there is a role for the Equality and Human Rights Commission to be that scrutinizer of human rights and the environment for human rights in the UK, and to come in and scrutinize the Information Commissioner as to how much it is defending and upholding those rights in the digital framework. And periodically, I think that the best thing would be if there's an amendment in the bill which requires them, say, every 3 years to periodically and systematically review that, send it to the Select Committee, and the Select Committee can then take some ownership of that. Of course, it should also be published. Even if that doesn't go through, in my view, the Equality and Human Rights Commission already have the powers to conduct those sorts of reviews, and they should see themselves more of a scrutinizer rather than just raising issues which are there. A scrutinizer, a bit like the Fundamental Rights Agency of the EU has done a bit of this, but again, not quite enough. A scrutinizer of whether institutions are upholding people's rights and whether people have a real remedy, because I think it's the lack of a remedy for data subjects that is the most pressing enforcement concern when it comes to GDPR. Okay, so thank you very much.
It's a good line. Yes.
David, thanks ever so much. I'll introduce our next speaker. I still feel like saying that you are the new General Counsel at the ICO, but you're going to tell me how long you've been there, and it's probably a lot longer than I imagined. But I will just make one other observation. I've sort of monitored the ICO for many years and how they enforce. One thing I have noticed recently is a real openness to talk to practitioners, academics, and even journalists about how they regulate and enforce. So I'm really delighted that Claudia Berg is here today, General Counsel of the ICO, reasonably new.
Reasonably new. Thank you. Thank you so much, John, and thanks to David and CIPIL for hosting the conference. I think, it really is brilliant to bring so many interesting people together, and so we can listen and learn and, share some thoughts. So as you've said, so I, just by way of brief introduction about myself, because it is true that I'm still reasonably new. So I took up this role 2.5 years ago, and before that I was at the Competition and Markets Authority doing antitrust enforcement for about 8 years. So I do have some experience in terms of enforcement. So I have done dawn raids, compulsory interviews, many information notices, dealt with whistleblowers, imposed many fines, and fought successfully many procedural challenges and substantive challenges in the courts. And just by way of example, so I want to, before I start, pick up on 2 really important points you made, David. 3, actually. So, for example, in 2016, we imposed the then biggest ever, one of my, as I call them, babies, fine, 84 million pounds on Pfizer for, this was at the time the biggest competition law fine ever imposed in the UK, for basically, we said unlawfully raising the price of a very important epilepsy drug, phenytoin, and thereby abusing a dominant position, as it's known in competition law. This was in 2016, 2 years after I joined the CMA, and we're still in court. So one other thing I want to say is enforcement is by definition a marathon. It's not a sprint. However fast you do it, however well you do it, it's a marathon. You want to do a sprint, you got to go somewhere else. But I like marathons. Anyway, so in terms of the 2 other points you raised, in terms of the complaints and then actually you made 2 points about complaints. First of all, the fact that in Killock and Veal, and thank you by the way for taking these cases to court. I think that is incredibly important. I come on to say that it's very, very important that the government generally, including the regulators, is accountable under the rule of law to the courts. I think that's hugely important in the interest of transparency, also in the interest of legal certainty, because it's only by having a good throughput of cases through the courts that we see legal certainty. I do think, however, personally, I think that as a matter of principle, I think both these decisions, Dello and Killock and Veal, are correct in the sense that we were pleased, especially, of course, with the Court of Appeal decision recently where we won, that the Court of Appeal confirmed that the ICO has broad discretion in deciding the extent to which it investigates each complaint and is entitled to reach and express a view on the complaint without necessarily determining whether there's been an infringement. Now, whilst I understand that that might not always be great for each and every complaint, but as a matter of principle, regulators have, notwithstanding the fact that there are a lot of people work them, limited resources. So in principle, the duty is that we prioritize our actions, and we can come on to the individual issues that you've highlighted, but in principle, you have to try and give the taxpayer most bang for their buck, and that means you have to be able to prioritize. Now, there is actually one, in terms of what you said, so the principle is right, it is correct, it has to be, and you might then criticize those individual prioritization decisions rightly or wrongly, but as a matter of principle, that makes sense because you have to be able to deploy the resources effectively in theory. Now, what's very interesting what you said about these public interest complaints, so in competition law, there is such a thing as a super complaint. Might be worth looking at, which is, so basically under the Enterprise Act, designated consumer bodies like which, for example, or Citizens Advice are entitled to make super complaints to the Competition and Markets Authority. And then within 90 days, which is not a lot, the Competition and Markets Authority has to say publicly what it's going to do about it. Now, it still might mean nothing, but that's the CMA takes this pretty seriously, and some very interesting issues have been, dealt with as a result of these super complaints. So that might be, something you were thinking about. So now I want to talk not too long because I do think it would be great if we have time for discussion actually, but 3 points. I just want to talk in terms of changing landscape of enforcement. First, a little bit on AdTech, because I know that's a matter close to many people's hearts and for very good reasons. Then a tiny little bit on the bigger landscape, because I think, we are now operating in an increasingly complex regulatory landscape with different pieces of legislation. They all intersect, they all interconnect, and you can't just sit in the little bubble, whatever the bubble is that you choose. And some of the answers to some of the problems might lie, for better or worse, might lie elsewhere, because, especially in the context of prioritization, we always need to think about whether we're actually best placed to act, and we might not be. And if you've got a problem and someone else can deal with it more quickly and faster, well, that is good. And then thirdly, I just want to highlight some of the work the ICO has been doing in order to sharpen up the toolkit that is absolutely necessary in order to credibly enforce the law. So I want to talk a little bit about the data protection finding guidance, which has been laid in Parliament, was published on Monday, I think. An incredibly well-drafted document, but happy to take any comments. And also some work we're doing on the procedural guidance. So just in terms of AdTech, this is a very expert audience, so that, the general position of the ICO, it still is that AdTech remains a strategic priority for the ICO, but there is a lot to do, absolutely grant that. And the ICO did identify significant concerns in 2019 and then yet again in 2020 that you are all very familiar with. And I know that there are some real experts in the audience. So again, very happy to take comments. And as you said, David, the work, so in 2019, we said, look, there are some big problems here in terms of scale of the processing, the lack of transparency, the lack of lawful basis for data processing, which obviously has led to some extremely interesting case law decisions by the, which is a great example of where actually the competition authorities and the data protection authorities work hand in hand. Bundeskartellamt, in a way, was the first regulator to really tackle these issues in Germany. And I remember I was at the time, and I didn't know very much about the GDPR. I was at a conference in Germany, and someone said to the German competition authority, but why are you taking this case? Why isn't the data protection authority taking the case? And the person from the competition authority said, well, quite frankly, it's not like we had to elbow others out of the way in order to do it, and someone had to do it. Now, I will say, I'm very happy to have a conversation, but this is very much a competition law case. So people often say, oh, it's a data protection law case, and of course, it was, why is the competition authority dealing with this? But it is a competition law case that at the same time also happened, there were GDPR breaches. So it is very wrong to say that this is a data protection case and somewhat, and the competition authority kind of took over or something. It is very much a reasonably, orthodox, I would say. I mean, not in America, but in Europe, a competition case. So we then had, as you said, David, the work was paused absolutely as a result of COVID, and we have tried to kickstart that again with a number of audits in the data management space in particular. There are two recent examples I want to point to. One is a bit of an old chestnut, I know, for a lot of people, but we've done some work in the cookie space. We published in November 23 an open letters to 53, more than half of the UK's 100 most visited websites. We set out concerns that we had that a large number of the UK's top websites don't give users fair choices over whether or not to be tracked for personalized advertising. We did say that we were considering enforcement action if they didn't bring the practices in compliance with the law if needed. And we had a fairly positive response. 38 of the organizations that we contacted have changed the cookie banners to be compliant. Now, you might asking, what are we doing with the rest? We are definitely looking at the ones that have not complied very closely. And we will be rolling this out going forward. So we will be doing taking quite a forensic look at the UK's top most visited websites. And then I would like to point to a case that sometimes is overlooked, and I think unfairly so, which is our TikTok case. A case I have certainly invested quite a lot of my own time. And this is a case which really straddles not children's privacy, but also AdTech. Because in April 23, we issued a 12.3 million fine to TikTok for multiple breaches of data protection law between May 2018 and July 2020. And in terms of the discussion on the previous panel around assignment of responsibility, which I think is a very important discussion, and thanks, Michael, for that, we did address the decision to TikTok Limited and TikTok Inc. But so we have both the UK entity and the US entity are addressees of that penalty notice. So I think very briefly on the case, we estimated, so one of the core infringement is about failing to process children's personal data lawfully, and especially children under the age of 13, so very young children. We estimated, and in cooperation with Ofcom, actually, that TikTok allowed up to 1.4 million children under the age of 13 to use the platform, because, as you probably know, TikTok's sign-up process at the time simply required self-declaration of age. despite TikTok's own rules of not allowing children under the age of 13 to create an account and use the platform. We said that as a result, TikTok processed the personal data of children under the age of 13 in order to deliver targeted ads without the consent from their parents. And this was in breach of Article 8 of the UK GDPR. Now, of course, they didn't have consent because these children are not even meant to be on the platform. So we identified also some other failings. This is all in our published decision against TikTok, which I would encourage you to read. And since the decision, we've had TikTok filed an appeal, which again is obviously they're perfectly entitled to do that and is a good thing because that will bring us some much needed clarity in some of these areas. Watch this space. I think I would like to draw your attention to a very interesting question here, which is that in November we had an initial hearing and the first-year tribunal decided to deal with one particular question by way of a preliminary trial. So we're actually not going to hear, what the case is actually about until this preliminary question has been decided. And the question is whether the monetary penalty notice was given with respect to processing for the special purposes. Because as you probably know, under Section 156 of the Data Protection Act, if the commissioner gives a penalty notice with respect to processing for the special purposes, it has to, amongst other things, get leave from court before doing so. Now, we, as you can imagine, did not think that the processing was given with respect that the MPN was given with respect to processing for the special purposes, but that is now kind of the next big question. And it is a very important question more generally for enforcement. So in terms of the changing landscape, I would keep a close eye. We're fighting, we're defending this decision. If the court finds against us, then the result would be that the ICO acted ultra vires. Now, I'm very much hoping that that's not the case, but we shall see. 2 more points before I hand over. So in terms of the wider tech regulation, I mean, again, you all know that obviously we're seeing wider tech regulation emerge in the European Union and also in the UK, which is really a response to the and we had this same in the competition market. So there was a bit of an emerging consensus, I guess, on both sides of the Atlantic that, the legislators and regulators had to some extent taken their eyes off the ball, being dazzled, by, like everyone else, by the magic of the internet. And it's true, it's been amazing. I mean, some people have said it's the best and the worst thing that's ever happened to us in a long time. And we have seen all the wonderful new services without which we cannot live. But there have also been, because especially of the decision in the early 2000s not to hold the platforms responsible for the content that's hosted on them, we've also seen some pretty harmful effects in terms of content harm. We've seen poor outcomes for consumers and obviously very poor outcomes also in terms of privacy erosion. Now, we're now seeing the reaction to that. We're seeing in the European Union, the Digital Markets Act, the Digital Services Act, the European Commission is starting to take action. In the United Kingdom, we have the Online Safety Act. We also have the Digital Markets Competition and Consumer Bill, which is about to get royal assent, but it's a bit like our own, the DPDI. You're always thinking when it's going to be, we don't know. And one important, just one example to illustrate here the intersection and the overlap, especially in relation to AdTech, is Article 5 of the Digital Markets Act that now says that for the gatekeepers, i.e. Google, Meta, TikTok, the usual, the GAFAM plus TikTok, they have to process personal data in order to, for the purpose of delivering targeted ads on the basis of consent within the meaning of the GDPR. So that's very interesting. And we now need to obviously wait and see what the, what will be the equivalent provision in under the DMCC, which is not quite clear because the Competition and Markets Authority has been given much broader discretion as to how it regulates the gatekeepers than the European Commission. So finally, just a very quick word on, our own work to sort of make sure we've got the right toolkit in place. It is very important based on my experience in enforcement, with everything really. In order to be able to credibly enforce the law, you need to have the right tools, you need to have the right people. And we have now, we've published our finding guidance on Monday, and we're also working on procedural guidance. Please read it, even though it's obviously now final. We did consult on it and had some interesting suggestions, some of which we took on board, some of which we didn't. So one was, I think, a suggestion that we shouldn't look, as Michael said, for the purpose of imposing a fine interestingly, in the data protection legislation, we look at the undertaking, which is really a competition law concept, which basically means a corporate group turnover rather than, just the data controller. There was a suggestion that we shouldn't do that, and we were like, no, thanks, we will. So, the key, I think what's really important from the finding guidance, it obviously applies the factors listed in the Data Protection Act, and also what you said, the core principle of any fine is it has to achieve deterrence or be dissuasive, in other words, but at the same time, it also has to be proportionate. So those are the kind of two. Why there's the third, effective, to be honest, it's pretty much, I don't see a great deal of difference between effective and deterrence/dissuasive, but those are the sort of key pillars in terms of determining a fine. And I think the art is really, you need to have the guidance in order to give people transparency so that they understand what to expect in theory, but at the same time, you have to have enough flexibility in order to adjust the fine to the specific facts of the case. What we have done in a nutshell is that we've got a traffic light system now, where we're basically going to classify infringements in 3 categories: the most serious, the medium serious, and the lower degree of seriousness. For the most serious, we will use a starting point of between 20 and 100% of the relevant legal maximum, which of course can be 4% of global annual turnover. And then for the medium ones, it's between 10 and 20, and for the lower degree of seriousness, between 0 and 10. Now, the procedural guidance, just to conclude, is really, again, something is very important to have, public procedural guidance in place that sets out exactly how you run an investigation. When do you launch the investigation? How do you exercise the powers? What are your limitations? What are the limitations on your powers? Like, for instance, legal privilege. How are you going to deal with this? What happens if someone, if you send that is obviously totally... it's right that any recipient of an information notice has a right to withhold legally privileged information. But how do you determine whether the document is legally privileged? Because we're not going to sit there and take someone's word for it. Now, there are processes with which you can do this, and this will all be set out in the procedural guidance. The draft will be published for consultation later this year, I hope, and then I would really encourage you all to provide us with comments. With that, I think I'll hand back to the panel. Thank you.
Claudia, thank you. I don't actually know how to get your slides up. It's probably incredibly straightforward.
I'm not sure that it can be done on because it's a graphic file, but I think we're going to trust it very much. You're my just there. So.
So I mentioned I chair the National Association of Data Protection Officers. I've done so for about a quarter of my life, I think, so I'm certainly not new. Jim, I don't know how long you've been executive director or in seniority at the Open Rights Group, but it's quite a while as well. So again, lots of you will know Jim, but he has been executive director of Open Rights Group, who've done some tremendous work, civil society work, bringing legal challenges, lobbying over before your time. Even. So
Getting on for 20 years.
Yeah, really delighted that Jim's here. Hopefully you'll be able to clear that weird thing about Acrobat, but over to you.
Thank you very much. So let's not take the tour or sign the document. All right. Okay. So I'm going to step back to roughly where David was and kind of focus in a little bit about what is going on with the strategy around data protection. What exactly is going on? I'm kind of going to think of this, try to make this really simple and binary, right? There are two broad things we should be thinking about. Is the Data Protection Authority, as David described, about the dissuasion, about people kind of knowing that they shouldn't be taking risks, which is a along the lines of John Byng, who got himself executed for failing to defend something or other. And Voltaire, famously said that he was executed to encourage the others, right? Pour encourager les autres. So that's the concept I think we have with data protection. You find people in order to encourage better behavior from the others. Right? That's what it's about, fundamentally. That's the model proposed in GDPR. The alternative is that you try to fix every problem as you go along, which is essentially whack-a-mole. And what I'm asking you to decide today is whether the current enforcement strategy fills the criteria of dissuasion, persuading the others to behave better, or whether it is in fact a policy of whack-a-mole. So, quick thing on org, probably don't need to know all this. 2005 founded, Cory Doctorow among them. We've got 11 members of staff, work on privacy-free expression, and we've got particular interest in various sort of aspects of privacy, including pre-crime, migrants, Online Safety Act, and now the Data Protection Digital Information Bill. Did that work? No. Right. So you also probably know we've got an interest in ad tech. We made the complaint that's been referred to a few times. Notably, in that case, the court agreed there's a problem with accountability around the ICO. They said it isn't entirely our job to fix it, but there's a problem here. Could somebody else fix it? And maybe Parliament should look at that in this current round. We've recently just filed another complaint to the ICO about LiveRamp and their kind of model of merging online data with credit reference data. And we also successfully challenged the immigration exemption, which has been talked about on 3 separate occasions, I think it was. The government just kept kind of evading actually doing what the court asked it to do. Ash spit. Slow. Right, there we go. So quickly then on, So quickly then, what is a DP enforcement about? As a regulator, it's court actions. Court actions we've heard, it's difficult. There's no class action model. So we're very reliant on the ICO for enforcement, data protection to work. Also heard about the role of the ICO. It's about monitoring and enforcing GDPR, as these duties to investigate, duties to advise, and so on. But the main thing is they've got to monitor and enforce. So, and we know about the sorts of things it does. The key instruments are enforcement notices, do this please, or rather, or you'll face consequences, and the fines, which we've also heard about. So I want to take a closer look at the last year's work of the ICO. That's really what I want to do today. So the ICO does issue fines, but as we've heard, most of these are PECA related to spam and marketing email. Nothing wrong with that, of course, but it is the majority of the fining that takes place. There are very few enforcement notices going out, and most of the problems that, if you look at the ICO's last year of enforcement actions on its own website, they're answered by something which is called a reprimand, which is in a sense a slap on the wrist. Now, firstly, I wanted to say I think it's incredibly helpful that the ICO publishes these. I think it enables a public debate about exactly what is happening. That wasn't the case a few years ago. We did hear about all the great work the ICO does in the background. We didn't really know what it was. Now we do. That is incredibly helpful. It will move us onto a better debate. If you look at the reprimands, the majority are directed against state bodies, which the ICO is very reluctant to fine. It fines the state bodies once in this last year. That was a case of the Ministry of Defence leaking the personal details of 280 odd Afghanis who were no doubt put in extreme physical danger. And they were fined £300,000 for that, which is another way of saying that the fine equated the life of an Afghani by about £1,000 each. I don't really feel that's a serious kind of fine. for that kind of thing. To be fair, the ICO I think did want a larger fine, got negotiated down, but that is the situation. Some of the problems that you see in the enforcement notices have persisted for the whole 6-year period, 2018 to 24, and that's kind of described in the notices as well. And the ICO's advice in the notices seems very focused and narrow. I think often the problems that they identify reflect rather deeper concerns. And it might be something there to think about whether enforcement notices could be a bit more broad, like get your act together, as opposed to, well, stop using BCC, which is the kind of advice, or train your people not to use the BCC, which is the kind of advice you see in these reprimands. So here's a few examples of reprimands. There's a school in Finham this year which has had 3 separate security breaches. And in the last case, I don't know about the other 2, but I assume they were all reprimands. So 3 times they've been given reprimands and they're still failing to get their act together. There are 2 police authorities and 2 councils who've had overdue subject access requests, backlogs, since 2018, right? Since 2018, and they are still receiving reprimands. This year, they were given a final reprimand, which I presume means next year they might get a fine or a enforcement notice. But you have to ask, if people are repeatedly getting slap on the wrist notices for 6 years, is that any kind of deterrence? And what is the lesson to be learned for any other public authority in that situation? If you ask me, the lesson is, if you want to make some cutbacks, do it to your SAR department, because you won't get fined. The worst that'll happen is you'll get a slap on the wrist. So if you've got some other compliance problem, put your money there. Don't bother with data protection. That's the message it's sending out. That's a problem when we're meant to be doing exactly the opposite in this strategy. There are 200,000 unauthorized recordings made by Sussex and Surrey police. Again, slap on the wrist. An abuser, their address, a victim of abuser's address was released to their abuser by Dorset NHS, also by Charnwood Borough Council. That's physical danger people being put in. They were given a slap on the wrist. Thames Valley Police disclosed witness addresses to the criminals accused in their case. There was another similar case in Nottinghamshire. Both police authorities got a slap on the wrist. There was a catastrophic loss of data in the West Mercia Police and Warwickshire Police Forces. They lost all their data about all of the risk assessments, everything they'd done. They got a slap on the wrist. The Bank of Ireland made, this is not a state thing, which is unusual, and they say, and it'd be interesting to hear a bit more background, but they made serious errors in people's credit records. People might have been denied credit. They got slapped in the wrist. Not quite sure why. And there were a couple of cases of WhatsApp and Telegram being used to share personal data, such as patient data by NHS Lanarkshire and Dover Ports was to do with vehicle registrations. Again, slaps on the wrist. So that's just this year, right? I haven't gone back further, and there are worse cases further back that we could be talking about. I've just tried to take a snapshot of this year. So core things to learn or to observe. Some of these problems have persisted for 6 years. Just seems incredible. The ICO has published a blog noting many of the common problems and features of these as advice. But surely this shouldn't be advice. This should be issuing fines to create an incentive. But it is interesting that they see commonalities, because maybe that can lead to a sort of sense of where enforcement might need to be. Mostly it's unclear why enforcement orders are not being used, particularly where there's like repeated security issues in companies. Why not advance to an enforcement notice? You obviously you don't want to discourage people from reporting the problem in the first place, but you do need at some point to kind of say, well, here's how you sort yourself out, given the seriousness of what's happened. And perhaps they could be broader. They could require certain elements of information governance or DPIAs to be conducted, that kind of thing. So, whack-a-mole. Which have we got? It's a whack-a-mole machine in case you haven't worked it out. So have we got a system of punishment to encourage the others, or have we got whack-a-mole? I'd say it's more whack-a-mole than encourager les autres. Several cases where the recipient just clearly hasn't taken the ICO seriously at all. Seems to me that can't be then advancing others to think about this as a board level issue. Many of the institutions that have been given reprimands are handling very sensitive personal data, NHS, councils, police. If there was other sorts of things that were going wrong, they'd get fined. So why they would get punished? Why is data protection a special case where state bodies can, particularly state bodies, can act with impunity and face nothing? Which kind of leads us back onto the bigger picture. Who exactly is watching the watchers? How, as David was describing, might the ICO be itself encouraged to behave rather better? Some suggestions. Parliament could be appointing the commissioners rather than the government, and if Parliament was making the appointments, perhaps they would feel more political responsibility for the actions of the ICO. Because after all, if they've appointed good or bad people, then their performance matters more to their political careers. Gosh, you really did that? At the moment, it's not really their problem. Reviewed by EHRC, that again, a very good point, something that could be done easily enough. Similarly, challenging specific cases through data community, some kind of collective redress, and routes to challenge the ICO enforcement decisions that is short of judicial review. All of these have come up in prior discussions, but these kind of measures are needed if the ICO is going to feel some incentive outside of its institutional framework, I would suggest. However, I don't want to put all the blame on the ICO for this situation. I think that would be deeply unfair. And again, I would just say, we have to be incredibly grateful for the information that's been put forward because it allows us to have this discussion. I wonder some points whether that was a little bit deliberate thinking by people within the ICO, that this should actually be, a way that perhaps some debate around some of these things might happen. I hope that's the case. But in any case, whatever's driven the decision to publish, that has to be congratulated. However, I do think the problem is probably political. But the ICO is not in a situation where it's being driven by politicians to do better. Data protection has not been a huge concern within the UK's political scene, I would say. It hasn't focused down. Obviously, there are questions around IC independence and enforcement. Those things matter for adequacy. That's a debate we can have. I think the ICO does need to make a better case for enforcement to encourage the others. And I think in this material you've seen, right, the things that the ICO has, to its credit, uncovered really matter. These are not trivial or abstract things. They're things that really affect people. And that's how you persuade politicians that data protection matters. So I think the ICO should be both punishing some of those people and really projecting the message that what this is doing to the constituency MPs and to other people and committees, to show that data protection is a fundamental pillar of fair outcomes in today's society. I think the strategy, has to include state actors in a more serious way, and it has to widen over time. I think that some of the things that the ICO is doing in that strategy at the moment seem to be just quite repetitive. I mean, to have to take half a dozen organisations through complaints about SARS for 6 years, or 4 organisations, that's a lot of waste of resource. And, maybe just clamping down on those first would clear up time in the ICO's overall work to focus on the more important things like the TikTok case. Also, AI is of huge political concern. The ICO will need a model for kind of persuading politicians what its role is in that, and that it can deal with those more complicated things. But while it's sort of still fishing in some quite low-level things, I think that's quite a difficult argument to make. So I think, basically, it needs to a tougher strategy is my message. I also think it needs political support, and I think we all need to think about, including the Open Rights Group, need to think about how we persuade politicians of how this and why this matters. But I also think that's actually quite easy given the material that's out there. That's it. Thank you very much.